Right, we've got the judges panel. Now remember, you must treat the judges with all proper respect. The collection of judges is known as a wisdom of judges. Anybody who suggests otherwise, we know what judges can do to people. Now, I've got a bunch of questions. First of all, some of them are going to do a little presentation, some are not. But basically they're here to answer my questions and your questions. So let's have a little presentation first. And let's start off with the view from Munich.
Okay. So, sorry, but I don't have a presentation to present to you, but I have presented the issues we had been talking about just seconds before the break. And one approach or idea we had in Munich is that we have the very specific Munich procedure in patent infringement cases, which consists of 2 oral hearings, the first one and the main one, and in between whatever 3 or 6 or 9 months, that we could have a ADR carve-out window in between these 2 oral hearings. The benefit of that would be for the parties that in the first hearing they will hear from the panel's view on claim construction and infringement test, and with this wisdom could go into ADR, which could be in-house, as we have an in-court mediation service, or out-of-house, as we heard today, to Tokyo, to the ADR institution there, or to any other ADR institution out of the courthouse. And if they don't settle there, come back for the main hearing, and then the state court trial just goes on with few or no delay. And why would that be beneficial? If you go to ADR, you can pick the person to decide your case. If you go to a state court, of course you could pick, like forum shopping, the court you will approach, but usually you're not able to pick a specific person to be the judge. So, for example, if you go to Munich, there are 2 divisions competent to hear patent cases. It's one of the 2 panels who are going to decide. If it's Düsseldorf, it's 3 of them. And if you go to the High Court of London, it's, I don't know the system, but it's not a specific person you could pick to do that.
There are 3 main patent judges, and
however, it's not a specific person you could pick. Yeah. And if you go to ADR, of course, you can pick a specific person with specific abilities or a specific background, as I heard today, first time for me personally, that
when they can pick.
An Asian background is for some parties beneficial.
As soon as they get a chance to pick, they start fighting over who it should be.
Okay.
So the fight is not about the case anymore, it's about who the arbitrator should be.
Anyhow, so the other benefit would be that you can kind of outsource difficult matters. And they are difficult to handle for procedural reasons and for material reasons. First of all, the legislator doesn't give us any guidance so far. We have the Treaty for the Functioning of the European Union. There we know that it's inadmissible to behave in an antitrust way, but nobody knows exactly what that is. And the full stop, nothing more. Then we have some case law of some German courts, and there are many German courts competent to hear patent cases. That's why we have so much case law, which may, of course, be contradicting. That's as long the case is not decided by the Federal Court of Justice. And it takes some time for a case to come all the way to Karlsruhe. But the major issue is the procedural one. So we could handle the material one. In the lack of any activity of the legislator, the judges just invent their law and apply it. Yeah, that's our job. That's okay. But the procedural issue is what has been discussed, that there is a wish for to keep trade secrets secret. So if you have a non-disclosure agreement in previous license agreements, you may ask the court to exclude the public. This is possible, but it's a very hard job to do, and you must not overdo it, because if you overdo it, your whole judgment may be void, just because of that. Because the public has an interest and a right to be involved in court hearings. And what is also not possible is to exclude the other party to take notice of the material you present to the court, because this is a constitutional right, at least in Germany. So the only thing to do would be to outsource the part of proceedings involving this delicate information to an ADR body, where they may have more possibility and flexibility to handle these kinds of issues. The maximum result would be for a standard case involving the infringement of an SEP would be that the state court, the Munich court, is handling claim construction, infringement test, and the test whether or not to stay the proceedings, and anything involving FRAND obligations is outsourced to this ADR institution, and the answer when they come back is, okay, we settled, or if they're not settled, the ADR institution says us that the offer of the patent owner had been FRAND or not been FRAND. And that's the information we need as a state court. And this is also the information which is so hard to obtain inside the state court because of the procedural issues at hand with confidentiality.
I'm going to ask you straight away.
Yep.
Quite a lot of these SEPs are invalid. And it's no good going to the state court. Because you've got bifurcation. So in the dispute, in the real dispute between the parties, validity is often a very live point. And in fact, claim construction is probably, and even sometimes essential, is not as important as validity. So how are we going to deal with that?
So if the only issue between the parties would be invalidity, the defendant could, when answering the statement of complaint, point this out, and we would amend or streamline our proceedings to cover this issue. But usually they don't do that. That even if validity is the only issue at hand, they will argue that it's not infringed.
Yeah, well, I know, that's because they're forced to in your court. I think it's a hugely problem because you've got three issues, or maybe four. You've got essentiality, validity, infringement, and then the FRAND questions, four issues. How much? And they all play one upon the other in any negotiation. And unless you can have them all playing together, you're in trouble. Now, you may have another view, which I'd like to ask you about, which is what happens. I'm not sure they were right, decided we would test validity first, validity and infringement and essentiality first, and then go on to FRAND as a second stage. Is that what would happen in Germany? And does anybody think it's a good idea to do it that way around, or say, well, never mind those, we'll start with the FRAND rate?
Well, we could test invalidity first in front of the infringement court, and the result of that would be whether or not to stay the proceedings. So this could happen. We didn't do it yet, so because nobody of the parties asked to do that.
You're really at another level discussing the difference between bottom-up analysis and top-down. The top-down probably starts with FRAND and divides up the share of the pot. The bottom-up is dealing with EVI, essentiality, validity, infringement, to determine what is the strength of the property interest that you are evaluating. Seems to me like you've got to have some element of both, don't you, to really make an accurate assessment of...
You do when you're doing FRAND. There's a jurisdictional question first in Unwired Planet. Right? The defendant said, none of your patents are any good. There's no jurisdiction here in anything. We don't need a license. Never mind how much it should be. and they lost that.
This is not an unusual argument.
Yeah,
It's
well,
often the opening argument.
It's quite realistic, because I mean, Nokia, Clemens will tell you how much they spent over the years, but they took on an outfit, and they said, all your patents, they bought them from Robert Bosch. And what were they called? IP Com. They said, we're not paying you a bloody penny, because none of your patents are worth tuppence. And I think they won every case. Every patent was held invalid except one of them, where he upheld it, and the European the European Patent Office knocked it out.
You
the
get
next
equal
day.
time, by the way.
And the European Patent Office knocked it out the next day. So Nokia were right; they didn't have to pay a penny except 70 million quid.
And the Court of Appeal said I was right and the European Patent Office was wrong.
It didn't matter. The European Patent Office win because they knock it out.
Well, and you're talking
but they-
validity.
that-
Generally, those who assess this area say the even larger problem for essentiality, where maybe as much as 3 or 4 out of 5 are not really essential.
Yeah, for obvious reasons. They're declared before anybody knows what the claims are going to be or what the standard is.
Exactly.
And they have to over-declare. Some people say it's wicked. There's some wicked over-declarers too. But even genuinely innocent over-declarers must over-declare, because if you under-declare, you get into real trouble.
But you're making the argument for there needs to be some assessment of EVI to make a proper valuation.
I think so.
I don't think anybody's yet worked out a cost-effective way of producing a determinative evaluation of a portfolio of patents. And so whichever approach you adopt is going to have to be a compromise. You can't go through the patents one by one and decide whether each one of 100 patents is valid and infringed and essential. So you have to get an idea of the portfolio, and if that's a combination of trying certain patents properly, if I may put it that way, and having expert evaluation in gross of the rest, then that may have to be the way to go.
I mean, that's what industry really does, is that's how they settle it. And don't forget, most licenses happen. So I mean, that's one of the things competition people the public face of SEB disputes is nothing compared with the secret underworld of license, cross-license, complicated things of various deals and whatnot, which is actually where it is all really happening. It's unfortunately gives the wrong picture that FRAND doesn't really work, is just what I think it may be seen by the public view. In fact, it is working despite all the bloody phones work. And why they keep changing, because there are lots of more inventions going to them every 10 minutes. So it's quite important that sometimes for the outside world to have a perspective. Right. Now then, would you prefer? Have you ever determined the FRAND rate?
No, because in Huawei and Unwired Planet and Huawei, the methodology adopted by Colin Burse was not in dispute by the time it got to the Court of Appeal, so the parties accepted that. The big battle in front of us was whether the court had any business setting a global as opposed to a purely national and patent by patent royalty. We decided that the court did have a proper interest in doing that. And so we never got down to the to setting of the rate or the nitty-gritty of the setting of the royalty. But that part of it, the what is FRAND or what is a FRAND price tag, is not an unfamiliar territory for the courts. FRAND and SEPs is not the first time that the courts have had to consider what's a proper rate to pay for a patent or a group of patents. It's certainly a more challenging backdrop to decide, because you've got hundreds of patents and you've got problems with affordability and royalty stacking and all the other things and competition considerations. But it's not a new question. Every award of patent damages, for example, usually involves the question of what is a reasonable royalty for this patent. And where the patentee is a licensor and doesn't exploit the patents himself, then all his damages are going to be assessed on that basis. and it comes in as a component of the damages in every award. So that's not unfamiliar territory. We also have, just picking up on the procedural question that Matthias mentioned, we also have developed quite sophisticated techniques for dealing with confidential information derived from license agreements. A long time ago, we invented the notion of the confidentiality club, that certain parties are given access to the defendant's technical information. That doesn't go to the patentee unless it has to, or it goes to one nominated executive in the patentee's organisation and nobody else. And that's a compromise we've worked out for dealing with confidentiality, so that you shouldn't feel necessarily that you have to go to arbitration just in order to protect confidential information. We've also we don't go into closed session to deal with confidential information, because in the vast majority of cases it's one number which everybody says is very hush-hush. And so you just tell everybody in court that they're not to mention the number. One or other counsel invariably does, but nobody knows. And there's a rule then that says you can make an order that nothing done or the fact that you've referred to the document in open court does not make it part of the public record, and it doesn't go any further than it's already gone. So that's a useful technique, which is to be compared with the blanket confidentiality it's possible to have in arbitration.
You've determined the FRAND rate, haven't you?
Several
arbitration?
times, yes, that's correct.
Do you find that a difficult task to do or not? Or do you agree with Chris that basically it's just much like doing damages?
No, I find it very difficult, and
So it was
it is something that even determining damages is not an easy thing to do. No nation has really come up with an ironclad formula yet for how you approach that. I wanted to hit another point, though, Robin. We haven't really talked yet about the anti-suit injunction problem, where in at least 2 cases in my country, you've had a district court ordering one of the parties that they may not enforce an injunction they've won in another court. That happened in Microsoft versus Motorola, where they enjoined the German court injunction.
Not the court, the party. Before.
The party is who's enjoined. You're exactly
put the
right.
German judge into prison if you could.
You're exactly right. It is the party that's enjoined.
Okay,
And in the
stage,
Huawei Samsung matter, they've enjoined Huawei from enforcing a judgment it won in Shenzhen. I would guess that this could be a more frequent occurrence. It would seem to me that it's standard advice to give to your client if you're being held up in one country to sue in your own country or in a more favorable jurisdiction to see if you can offset in the global market what's happening to you elsewhere. That would probably lead to more conflicts, which maybe that says arbitration is a system that avoids that kind of conflict. But
I mean, there's a big question. I mean, most of the judges I've talked to say, I don't want to do FRAND determinations as a judge. Of course, retired judges see it differently because they get paid. but most judges say they don't want to do it. And if you think about how long Colin Burst took, we had masses and masses of economic evidence.
and that was how many patents? 6, 8?
Well, it was the portfolio, but it wasn't it was a very small portfolio.
It was a small portfolio. Well, the one I did had 5,284 patents. Now,
Was any of them valid?
I mean, that's the point. That's you've got to face up to this. It's a bit like quantum physics. if you look at a mass, sort of, if you look at the individual thing, you look at the individual case, is this patent valid, is it essential, and actually, if it's competition, does it confer a dominant position, which is not the same as being essential, because being essential means it fits the standard, but it may be an optional bit of the standard, and it may be a rather unimportant bit of the standard. Therefore, it's not conferring market dominance. So you could have a whole lot of micro questions, but in the big world, you're now looking at a cloud of patents. And so suddenly you've gone into, from the quantum world of the little things, to a different world, the Newtonian world. A bit odd, really. But that's how it works, and that's how it works in industry. I don't know how you really work those things out. When I was writing a forward to a book about the Copyright Tribunal, I did suggest that one of the procedural orders that a court could make, the tribunal should make, is that each side be deemed to have called in the economist, and each has cancelled the other out. Because you only have to read the papers that people are writing. Some are for, some are against, and I don't know who's right. What do the audience think? If you were given a choice, let's take a little poll. If you were given a choice of determination FRAND by an arbitral tribunal or a court, how many favour a court?
The trouble is, it's a bit like the Brexit question. You say, what about a determination of FRAND? What do you actually need? Are you talking about a global?
Yes, a global FRAND rate for an entire portfolio. Okay?
Nobody.
And are we
One.
patentees or are we defendants?
Right? Okay. Let's break it up. Patentees, court or arbitration.
Well, court first.
Court.
There's about 3 hands, 4.
Does it make any difference which court? Okay. Arbitration.
You want your court, right? Not mine.
only one for arbitration.
Anyway, so what do you all say?
Oh, a few more that would work.
Yeah, a few more.
I'm for arbitration.
Yeah, there you are. You see, that's what judges think. Peter keeps telling me. He keeps saying to me, "I wish we had a FRAND case," and he's always telling me that. Aren't you, Peter?
I think someone put their finger on the real advantage of arbitration, because you can argue the toss each way on confidentiality, you can argue it on who the judges are and so on. But this question of where you decide your FRAND dispute, is it China, is it London, is it Munich, is it Paris? That is the question that you solve with,
You missed Texas.
Texas, Marshall, Texas,
Exactly.
that is the question that you can solve with arbitration, because where we've got to in this country, at least, is that because we don't assume jurisdiction to deal with FRAND unless there is at least one valid and infringed patent. Then it becomes ludicrous to say, well, you can go and try that action in China or in Munich or Texas or Düsseldorf, because it's in essence an action about a national patent right. And so the situation we've reached is, yes, you can do it in London, and if the laws are the same elsewhere, yes, you can do it in China, yes, you can do it in all these different places by picking a local patent and suing on that. And that is unsatisfactory, I will grant. And arbitration short circuits that entire debate.
If we move to an arbitration system that's setting market rates for a global system, and we recognize that the market in India is vastly different from the market in South America, from the market in the United States, is there some merit in having more than one arbitral tribunal, a regional European tribunal setting the rate for Europe, a regional Asian tribunal setting the rate for Asia? Now, the downside of that is it would be more expensive, but it might be more accurate.
Yeah, it might be. I believe, and I'll be corrected if I'm wrong, that many of the big FRAND licensors, in fact, give different rates for different parts of the world. I think Colin Burst gave a different rate for
Sure.
China.
Yeah, sure.
And it may be that you mark out the areas by what in practice people do, by way of saying this is a different rate for China and India. Whether they do the same, I don't know. But maybe they do, maybe they don't.
I liked the word trust that came from the prior panel.
Yeah.
Maybe you'd get more trust if you had a group of Asian experts setting the Asian rate.
But what I would like to point out that whether or not you go to the state court or to an arbitral tribunal, both are kind of judges, so they have to apply the law on the facts, and the facts have to be pleaded and, if disputed, proven in front of the tribunal. So any outcome may be kind of independent on personal experience of the judges, because it depends on the facts which are pleaded and proved, and not on the personal experience or knowledge of the judge deciding the case. He may trigger, because of his knowledge, specific pleadings, pointing out that there's a gap or something, but it can't replace proper pleading.
No,
Yeah.
that's basically, it's no good. It's no good having. It's no good saying I want an experienced judge, because he will know about how. He will know, or she will know, what FRAND rates are from other experience. That's not what judges do. You have to work on the stuff in front of you and nothing else.
The other advantage,
Yeah,
though,
but
of
there's a
having...
comment coming here, just Randy.
All right, sure.
His arm's falling off.
So, kind of rephrase a question I asked right at the beginning, Geoff Wild from IAM again, to Judge Rader. If you're a patentee, a patent licensee, and you can get your case in front of the Central District of California or the Northern District of California, you would be mad to agree to arbitration, wouldn't you? Because the chances are you're going to get exactly the FRAND rate that you want from the court. So, I mean, arbitration is pointless because you win in court.
Yeah, exactly. And you know what? As soon as you file in Northern District of California, my client is filing in Shenzhen or Finland or England. Do I want to file in England?
Yeah.
I don't know. That's not even in Europe.
We need it. We need all the help we can get.
And so I've got an automatic strategy to beat your system right off the bat. And of course, in saying that, I kind of cringe, because we're creating a system with an inbuilt failure mechanism where one jurisdiction will be pitted against another for as long as they can fight. Just that system can't work.
Assuming that you had, for some reason, contradictory royalty awards from courts in different jurisdictions, because you picked a Chinese patent and a UK patent and a Mexican patent, and all those courts set either global rates or at least overlapping rates. For example, the Chinese court for China and Japan, and the UK a global one, or such things. And assuming, you know, I don't know whether it's very likely, but assuming that anti-suit injunctions and all those sort of things do not prevent this outcome from happening, what would be the solution the parties should choose? I mean, which of those awards should they obey, or how would courts deal with that? How would UK courts deal with the fact that they have set a rate for China, and then subsequently a Chinese court sets a higher or lower rate for the same patents in their jurisdictions? So how does it work out? I know it's a mess, and I know it's not, perhaps not very likely to happen, but in case it happens, how do we deal with that practically?
Well, I can tell you in the U.S. that when the same patents were litigated in two districts within the U.S., and one had an enormously high rate on one patent and the other one had a very low rate on the whole portfolio, one of the judges vacated their opinion and started over. But of course, that's all within just the U.S. system. I think what really will happen with your situation is if you come up with conflicting judgments, then these guys are going to have to sit down and negotiate it. They're going to,
So we should have them.
the business minds are going to have to do what Robin says they do most of the time anyway, which is reach some kind of settlement.
Yeah.
This is one of the points that was made in the appeal in Huawei and Unwired Planet. They said, what happens if Mr. Justice Burse's rate, it turns out to be many times what the Chinese court decided is the right rate. But built in, and the answer we've given, and no doubt this will all be debated in the Supreme Court, but the answer we've given is that Burse's license, as it was settled, includes variation provisions, just as you would have in a negotiated license, so that that in a sense is provided for. It's not a perfect solution by any means, but at least it doesn't, you may not get to the point of saying the two judgments are inconsistent.
I see, and I see that adjustment clauses may be a solution, but I think they may work better with regard to many patents being subsequently invalidated by the courts in the jurisdiction by which under which the patents were granted. And I see that you could, somehow deduce a modification of the royalties. But if it is about royalty setting, things may be more fluent. For example, does a first instance judgment justify adjustment, And so I fear a bit that this adjustment clause solution triggers yet another, litigation phase over whether the adjustment is needed or not in that event.
Maybe the answer lies in the answer to a question I posed to you. Is the royalty rate Streitgegenstand in German or subject matter of the dispute? Because usually if you have a patent infringement dispute, you have a patent and you have an attacked embodiment and it's used the technology or not, so you have an infringement or not, and then you may have the argument about validity. And then you have the defense, the antitrust defense. And then the question pops up whether or not the patent owner, as he is obliged, offered a friendly license agreement. And that's the only thing to determine in this setting. You could make a specific global portfolio license rate to be subject matter of the dispute, but usually it is not. It's just an argument, a defense argument. So, if a different court may have the same patent owner with a different member of the portfolio being litigated, so maybe in Munich, patent 1, and in Mannheim, patent 2 of the same portfolio, you may have two decisions of Mannheim and Munich having a different global license fee, and that's totally correct according to German law. Unless we have a case of lease pendants, but this will only happen if you make the license fee part of the decision of the court itself, and not only as a defense of the defendant.
I think there's a lot of complications. First of all, don't forget, he hasn't exactly set a global license. He said, if you want to sell in the United Kingdom, you must take this global license because that is what a FRAND license is. And I don't understand
Just
how
a
you
defense.
Well, exactly, you either take a license. Now, if they take it and carry on selling their phones, they've now entered into a contract. So if another court gets to hear the case, what the court ought to say now is there is a license, we're not concerned with anything else. It's a worldwide license.
There's no infringement.
There's no infringement. There's nothing to see it. We've got nothing to do. We're not going to get involved in setting the rate at all. That is a possibility which I haven't quite seen the answer to.
I think Peter's question is directed to one court saying these are the global terms that you must accept if you want to sell here, and the Chinese court or the French court saying these are the global terms that we want to
Yeah.
sell here,
Exactly,
and
yeah.
the implementer has not yet signed up to either. But in practice, I mean, that's a pretty unlikely situation to arise.
In the music industry, whenever there is a copyright infringement claim, especially in the synchronization field, so whereby either a track or a music composition is being used without the prior authorization of the right owners, whenever a license is being negotiated at a later stage, there is a penalty because they actually took the right to use the music, be it the musical composition of the track, without the prior consent of the right owners. So when you are computing the royalty rate for your parties, do you take into account a penalty like that for FRAND disputes in particular?
I don't think the patent people. Are you from the music industry?
Well,
To some extent.
yeah. I mean, I'm an entertainment
Which is
media
one of the
lawyer.
questions which, I mean, there are parallels between copyright and patents in this regard. You've now got several million tracks licensed on Spotify, like thousands and thousands of SEPs. You've got maybe different rates in different countries, and you have worldwide licenses. It's very complicated, and sometimes they're not. They're not worldwide licenses. And I wonder whether there's any.
Okay, but going back to my point, what's the state of play in the patent license business and litigation? Do you also have this type of
Well, if you're
of
just setting
penalties
if you're
the
just setting the
current
royalty, then you just set the royalty. You don't take account of whether the defendant has infringed or has not infringed.
Okay.
But there may be back damages to take care of. And there is an argument out there, it's no more than that you're not restricted to the same rate for unlicensed use, because that royalty is negotiated on the basis that the patent is definitely valid. But that's a whole different area. But if you're just setting the rate for a global license, and you're not setting back damages, then no question of any differential rate could possibly arise.
Okay, well, so it's a nicer world than the music industry. Thanks.
May I just pick up on the copyright issue? Because it just popped to my mind that we have a very, very settled case law that, for example, if you use a copyright-protected picture in your homepage, and then you get a warning letter, and in response to this warning letter, you take it off. So you used it for 1 or 2 days. And then the owner of the copyright to this picture establishes in front of the court that he usually only gives out a 1-year license to use his photos. That's it. So he has to pay for 1 year. Also, in fact, he only used it for 2 days. And maybe you could transport this idea to the global portfolio license in SAP disputes.
Yeah, right.
Peter Meyer, Simmons & Simmons. You raised the question of the difficulties to say if there are 5,180 patents, what is the right FRAND royalty? And to deal with this, would there not be the ADR a possibility? If you have a bit creative running people, the ADR would say, show me the best 3 and the 3 worst on both sides, and you compare them and identify only the number of those patents and say the others must be in between and compare what the claimant and defendant or the implement and the other use, and then deal with, cut it down the whole bunch of patents to a smaller number, which is not possible in the state court, because in state you must decide what is put in front of you. If it's the one patent, it's the one patent, and maybe good patent, a bad patent. But ADR with some creative guidance, you probably can run this. And also, I think I agree with you, we talked about the centers in Asia and the other one. That, of course, will then be the comparability between the centers and whether they have the right interchange between them. But that would the smart solution not be to have then an Asian arbitrator on the panel and the like. So really have a multi-jurisdictional panel, and you cover that, and they have all in mind, and then get really running the show a little bit, what they want to see from the party, but differently, sort of mediator in this sense, rather than arbitrator deciding a case put in front of them.
On your point of pride list sampling, I do think can be an important part, but it has to be probably a two-step process. You'll have the pride list, then you'll have a random sample, and then the parties will have a burden to prove that those two together have somehow given an accurate vision of the entire portfolio, which can be as large as 5,000. The problem with that, to be honest, is it is an awful lot of work. It is an awful lot of expense. And so the parties might gravitate away from that, even though it may be a more accurate vision of the EVI on the portfolio.
You know the story of the Irish counsel who appears in front of the court and says, "My lord, I've got 17 points. Well, which is your best?" "Oh, that's for your lordship to decide." "I've got 5,481 patents. Which is your best?"
The alternative is, which is your best? Oh, it's European patent number 1, so and so and so and so. Well, I think that one's invalid, so.
Well, that's where you don't answer the question. I mean, that could happen in front of a court, but a court cannot make the party argue its best patent and say, "You decide which is my best patent," except by bullying.
It's not possible for the state court, but the question is for the arbitration, if they can say, maybe show me.
They
it's
can.
up to you to decide, do you put on invalidity, importance for the product, on essentiality and the likes. You must show me the best three and probably the worst three also. Show me your worst three. And then compare what the defendants say are the worst and the best three. And then we'll compare
In trying to implement that kind of a pride list sampling, I've found pushback often from both parties.
Colin Burst is worth looking at Colin. The portfolio was much smaller, but they picked 5 to sue on. And Colin said, "Right, I'll break that up into 3 trials, I think." And they didn't bother with the third one because the score was 2 1-1 wired after the end of the second one. It meant they had some substance, and then he went on to FRAND. And that's one way a state court could do it, is say, "Right, we'll try some first, and you can pick which one you want to start. And I'm not going to try the others until I've done those." That's the way you can force it on them. Quite a neat way. I mean, you're not going to sit through 581 patents, are you?
Definitely.
Right, any more? Yeah, Peter.
May I come back to Peter Picht's question and Matthias' remark? Once a court, let's say an English court, found that a patent owner complies with its competition law obligations if he offers a certain license agreement with a certain price tag, that may not cause res judicata for other proceedings in another country, let's say before German courts or Chinese courts or Texas court, wherever. But I think, nevertheless, once this question has been decided between the parties, this other court should be quite reluctant to say that the patent owner does not comply with its competition law obligations if he acts exactly as he has been decided to be in compliance with competition law by another, finally decided by another court. And that may be at least a practical solution.
Of course, it's even more complicated because I don't know how much you have in German law, but we have a concept of something called issue estoppel. And that is where some other court, in a properly fought case, has come to a conclusion of fact. I don't know whether the rate of royalty is a question of fact. Then we take that as a binding decision. Not the whole judgment, but that issue of fact was decided by that court there. You had a fair fight there. there is an undoing if it's not fair, and otherwise you're stuck with it. Issue estoppel, not cause of action estoppel, is the whole case.
We have the special feature here that the law, which we're supposed to be applying, whether we're in Germany or in the UK, is French law. So that there's no legal difference between the interpretation of the FRAND undertaking should be the same in both countries, and competition law should probably be the same between France and
I think even
Germany
more
and UK.
the concept of abuse of market dominance is more or less
That's a
similar
European
around the
concept.
world.
That
But
could produce different results in
Peter's
China.
point is also true, not only for the question whether or not an offer is friendly, but also whether or not an European, the British part of a European patent is valid or not valid. So if the High Court of Justice or even higher instances destroy the British part of this European patent, the German courts will very closely look at the reasoning, especially if they want to do the opposite.
And of course, Peter, a U.S. court wouldn't feel bound by your competition law procedures. We don't really follow the willing licensee, willing licensor dance that you have set up since the European Court of Justice has ruled. So it wouldn't necessarily have the same impact in the U.S. that it would in another European court.
Yeah, but the impact of this dance is also unclear.
My name is Feisch. I'm a former judge from a former court, and therefore somewhat of a dinosaur. I'd like to, before we lose the views from the bench and this galaxy of talent, I'd like to ask a very simple question. Mandatory, oh yes, let me begin again. What are your views, 1, 2, 3, 4, about mandatory mediation? Appealable orders made on the case management conference or thereabout, the judge's view, come on, bang your heads together, this should go to mediation.
That's what we do in France.
Yes, yes, and also in certain states of Australia, in the commercial court, the judge can do that. We can't, perhaps because of Strasbourg, I don't know.
I personally don't believe in mandatory mediation, because both parties should have the own will, maybe triggered by somebody else, but the own will to go to mediation and to search a solution. The scheme we have in Munich, as I pointed out before, we have the 2 hearings, and the first hearing you have the first view of the bench. And I think that's quite beneficial to trigger the will in both parties to go into mediation, because they have some view or some estimation how the case could be decided, how long it will take, how much money it will cost. So they see their alternatives. And of course, if we discover in the first hearing that there is a need for mediation because there's some personal kind of issue between the parties, this can also arise if you have 2 legal entities fighting each other. There could be some natural persons having been insulted, and this has to be talked about before a settlement is possible. So we send them into mediation, but practically or legally, it's their free will.
I mean, I've talked to a lot of mediators, and the general English view is you can take a horse to water, but you can't make it drink. And you can encourage people to go and mediate, but mandated mediation is actually not very productive and rather unfair. It is used, particularly in some cases in America, where the judge orders a mediation, but he's really probably not, doesn't seem quite fair to be doing it, and he's really trying to get rid of his list, because he's got a lot of criminal cases coming up. And so I stick exactly with the tires. You encourage it, and that's it.
I agree with that. I did learn about quite an interesting side effect of mandatory mediation. It was an experiment tried out in a state in the United States where they had mandatory mandatory mediation before, as soon as the proceedings were issued, you had to go into mediation. They found that actually increased the number of cases that were started because people wanted to get into that alternative dispute resolution system rather than going cap in hand to the other side and losing face. But that effect aside, I agree with Robin that you can't force reluctant people who are litigating with each other to mediate. And there are, however, a lot of things that can be done, including a scheme which we operate in the Court of Appeal in certain classes of cases where the parties receive automatically an approach from a mediator to a low-cost mediation service, so that it's already set up for them. All they have to do is say yes. There's no difficulties in arranging it, and it's all there for them to take, and the costs are already set out for them. So you can make it very attractive, but you can't actually stick their heads in the water.
I agree and would give a rough statistical analysis, and that is I've done about 10 mediations. 8 of them were mandatory. All 8 got nowhere. The 2 that were voluntary succeeded.
I mean, there's no reason if you order a mandatory mediation, the chap comes into the room and he says, "I'm right, you're wrong, I'm not saying anything more." The mediator says, "Well, say more. What about making an offer?" "No, I've just told you. The offer is he gives in."
Yeah, that happens with every mediation.
No, it doesn't. I mean, because I've done quite a few mediations, but they're all voluntary because we don't have any mandatory. Chap comes, "I am right, they're wrong, and I'm going to see these bastards in court."
But then there's the trouble with Strasbourg, too, isn't there?
What's the
That everyone
Strasbourg?
is entitled, sorry, I don't have the article, you probably know.
It says you're entitled to a fair trial, Article 6, but that's not that. Mediation isn't inconsistent with Strasbourg, and even compulsory mediation isn't. You still can in the end. Well, it is, because if you go to compulsory mediation, it doesn't work, and you've got a right to go to court. Voila. Okay, we're done, because otherwise we're going to get into the next session. Thank you very much indeed.